So we're going to get started. We're going to be talking about privacy issues and some other legal challenges to the drones. We're going to be joined up here on stage in a moment with Mickey Osterreicher, who's the General Counsel for the National Press Photographers Association. Mickey has been one of the leading forces in the area of drone legislations and helping the FAA and other organizations figure out how do you use drones, how do you use them legally, what are the ethical concerns that we have about these. And we're also going to have Sonja West. Sonja West is a professor in the University of Georgia's School of Law, so she's going to be joining us to talk about some of the privacy and legal issues there as well. So hopefully everybody's got a lot of coffee in them. We got a lot of stuff to get through today, so you're not going to see me too much. Let's welcome out Mickey Osterreicher and Professor Sonja West.
Yes.
Thanks, Mark.
Thank you.
Well, good morning, everybody.
Good morning.
Except with all the lights, I feel like if this is an interrogation. I have no idea if there's anybody out there. Name, rank, and serial number. Anyway, we're going to try and do this quickly. Some of you may have seen this, but just to set the stage, man has always wanted to fly. It's a quote from Leonardo da Vinci. It didn't take long in Paris, 1700. They decided to use hot air to get up in balloons. Around the same time, they invented photography. That's the first known picture taken in Paris again in that year. And it didn't take long before somebody realized, well, we've got hot air balloons and we've got cameras, so let's go fly and take some pictures. The first known picture was taken in Paris. It doesn't exist anymore, but this is the first existing one. It's Boston in the 1800s. Flash forward to our drones. Lots happened in between, the Wright brothers and all kinds of other things, but I'm trying to zoom along here so we can get to the topic at hand, and most of you know this already. I put this in. This happened in Buffalo. My wife is a director of photography for the Buffalo News. Unfortunately, we had a police officer die while he was training doing underwater recovery. And they lit the city in blue last night and used a drone to get that image. So these are the kinds of compelling images that could not be made before without, a drone or having a helicopter, and you wouldn't even have one that low. We've done some training around the country. I know a lot of you obviously are not here just for journalism, but the principles that we were teaching during the workshops for Part 107 are still the same. I was doing a little bit of training with police 2 days ago, again working with them. No matter what field you're in, whether it's real estate, you really, as I said, the first encounter you're going to have using a drone, no matter what you're using it for, is with a police officer. You're not going to see somebody from the FAA. So it's really best to let them know what you're doing ahead of time. So one of the cases that came up is Singer v. the city of Newton. And this professor from Harvard challenged a local ordinance. He brought the case in 2016, went through the courts. In September, it was decided that the government, the FAA, has federal preemption. And basically, this federal court struck down the ability of the town of Newton to control the airspace, saying that it was controlled by federal preemption. While I was doing research last night and just kind of putting the PowerPoint together, and these are just, so 63 documents were filed. The case was brought in January of this year. It was just decided 9 months later. It's very costly. We've talked about the cost of litigation and strategically what you do. The fascinating thing was this morning when I was looking, yesterday while there's the judge's opinion, but yesterday while we were all sitting here talking, the city filed its appeal. On the last day they had to file the appeal. So the case continues even though we thought the case was over. So it just shows you how it's literally like a stock ticker when it comes to drone use. The letter I talked about that AUVSI sent to the president, talking about a number of things in terms of how does the federal government work with the local governments. And these are all the organizations that signed on to it, DJI, NPPA, not going to list them all, but you can see major organizations. But one of the things that they really, we're not going to read all this, but in the letter that they talked about will be the underlined part. And Mark, I know, is having fun trying to keep up with me, trying to make what I'm seeing match what you're seeing, but I'll try and be kind to him. This is what they're talking about. Even though they want to try and work with local governments, and local governments have tried to fill the void while FAA was trying to kind of get its act together, they still think that the FAA should have sovereignty. What they were talking about was a sliding scale where local governments would control the airspace from the ground up to 200 feet, and then the FAA would take over for at least small UAS up to 55 pounds from 200 to 400 feet, and then we have the rest of the national airspace. So literally, the letter was sent to the president on the 11th. Yesterday, well, it was 2 days ago now, they announced that they're going to try and start a pilot program to see how that works. Again, so now we're up to kind of privacy, which brings in Professor West. My wife was kind enough to pose for this picture. You can see the looming drone shadow as she tries to have her private moment, having a cup of coffee, and being peered in. This is the thing that everybody worries about. So from there.
Thank you. And first of all, I want to say what an honor it is to sitting here with Mickey. I'm a law professor, which means I'm in a classroom a lot and in my office thinking more big picture or theoretically or hypothetically, as my students would say. And Mickey is really on the front lines and in the trenches about how this is all working. But I am going to take a few minutes here, and I'm also not a photojournalist who could take amazing pictures like that. A few minutes, though, to talk a little bit about what the law is related to privacy, which to a great deal the answer is we don't know. It's very uncertain. The law is something that moves very slowly. If you go to the United States Supreme Court, for example, they have decorated throughout the building with turtles. They have little turtles on their lampposts and turtles, and you can go around in the walls, and you can go to the gift shop and get a coffee mug with a turtle on it. And the turtle is there because they are supposed to be the slow and deliberate branch of government. So they're actually proud of how slowly they move. But it doesn't work really well when we're talking about technology, which of course can move very quickly. And that's certainly the situation we have here, where the technology has far outpaced where we are with the law. But nonetheless, it's important to have at least some understanding of what laws we do have and where there are gaps and where we might have lawmakers make efforts to try to what they consider, what they think are the right ways to fill those gaps. So as Mickey was just talking about, there's still sort of a debate going on about the FAA's sovereignty versus local and state laws. The FAA has, however, said that their mandate is really about safety. Privacy is still generally considered to be more of a state or local interest. So when it comes to thinking about regulating in the world of privacy, we have the states definitely starting to take notice. And of course, though, the First Amendment never goes away, again, as Mickey said, so privacy interests always must make sure that they can withstand a First Amendment challenge, which are very strong and robust in our country. But nonetheless, courts do recognize privacy interests in particular situations. So there's really three areas of existing law that affects privacy that could be possibly applied to drone use and that we have seen some initial cases thinking about. One is simply trespass. And trespass is indeed, as you probably know, it's when you enter someone's property without their permission. It can also be trespass if you cause a thing to enter someone's property without their consent, which is, of course, where drones come in. And the trespass is the harm itself. The entry is the harm itself, so it doesn't matter if there is an entry onto property and nothing else is damaged or nothing else is hurt. The question, of course, is this entering property? Where exactly is the property when we're talking about the airspace around or above? No one is actually touching the land. And originally, the law said a landowner owned their property from the depths of the earth to the heavens above, that you owned everything above and below. But then life came along, modern aviation came along, we quickly realized that can't exist. Today we do have sort of the acknowledged public airspaces, again, Mickey was talking about. And the Supreme Court too, however, has recognized that landowners do have some interests in the airspace around their property. There's a case in the 1940s where we had a family that owned a chicken farm, and they happened to live near what was being used as a military air base during World War II, so they constantly had planes coming up over their chicken farm, a couple hundred feet above their chickens. Their poor chickens got so scared, they would panic and try to fly away, and they'd run into a wall and they'd die, and the chickens kept dying. And actually, eventually, they had to close the chicken farm because they lost so many chickens. And so they sued, and that case involved the government, which is slightly different, but nonetheless, the court recognized that this was affecting their ability to use their land, and that there was an interest here. And in general, we see sort of a 50-foot range being accepted by the courts is clearly sort of part of the landowner's interests. You know, above 500, it seems very clearly public airspace, but there's this debate going on now about what we do with that middle ground. And we have seen some states trying to address this for privacy interests. Nevada passed a law specifically about drones and telling us that landowners own the property up to 200 feet, but they must first give a warning before there can be a trespass, so it would be the second time that that property was interest. Oregon has talked about up to 400 feet. There's also the area of nuisance law. Nuisance is where you unreasonably interfere with someone's use or enjoyment of their land. So this is different than trespass because you don't actually have to go on their land to be liable for a nuisance. And traditionally in nuisance law, we think about things like loud noises or bad smells or the smoke or pollution that might come from, you know, a factory in town. You know, the quintessential nuisance case is the neighbor's dog that just won't stop barking. So the question is whether having your neighbor fly their drone into your yard or your property, would that rise to the same level? And is it really a very good fit? Because generally in nuisance law, the courts are looking for a very substantial and unreasonable interference, and they often really care about frequency and duration and magnitude. So unless it's happening all the time and really frequently, it seems unlikely that most courts would consider it a nuisance. And then really the big one is the tort of intrusion into privacy, or lawyers call it intrusion upon another person's solitude. And here you are, what the courts would say, intentionally invading into the private sphere or the private affairs of another person. So this has been found to cover all sorts of laws that involve, you know, peeping or eavesdropping or recording or wiretapping, photographing someone without their consent. But there's some very key elements that the courts require before you can have an intrusion claim. It needs to be highly offensive to a reasonable person. So something very mild is unlikely to be considered an intrusion. If the person just happens to be, you know, exceptionally averse to being viewed or photographed, that won't apply. It has to be a reasonable person. And probably most importantly, it has to be in a situation where they have a reasonable expectation of privacy. So it is not an intrusion into your privacy if you are being viewed from a standpoint where you are either in public or you are visible to what we call the public eye. So even if you are sitting on your own property, even if you're sitting on your front porch, if you are visible to the road and the passerbys and the cars, you don't have an expectation of privacy. Even if you're in your backyard, if you have neighbors' property that can look in to your backyard, you don't have a reasonable expectation of privacy. And certainly if whatever you consider private can be viewed from the public airspace, there's not a reasonable expectation of privacy. The government doesn't need a warrant to surveil you from that distance. We don't have that interest. So again, it would lead a question to sort of what exactly is going on with the drone use. But some of the cases we hear about of flying in and peering into someone's bedroom, we certainly could have a reasonable expectation of privacy that could qualify as an intrusion. So as you're seeing, we have a lot of gaps in the current law for thinking about how this would apply to drone use, and we do have lawmakers who are definitely taking notice, and they are starting to talk about passing remedies that they think are going to be more adequate. And we have this growing patchwork of state and local laws affecting privacy. In fact, every state except South Dakota has now at least considered some kind of drone regulation. We have more than 30 states who have passed some kind of regulation of drones, and many of these do affect the issue of capturing particularly images and recordings without people's consent. And it's also worth noting that it is a separate kind of liability to publish or distribute private information that might have been recorded. So there's both the gathering of it and the publishing of it can be separate kinds of liability. And as you probably have already heard during this conference, here in Georgia, however, we do not currently have the laws. We only have a preemption law saying the state law is going to is going to be the governing law here. We have a governor who just created a commission, though, to look into these laws, so we might be seeing some more. So that's a little bit about what we know about the law so far, but there's the flip side of this. This is called privacy and ethics. So the law is what you can or can't do according to the government. Ethics might be more what you should or shouldn't do. And here again, Mickey's sort of frontline experience, I think, might be of help.
And it's really Al who talked about that yesterday evening. I'm basically looking at it as the law. The reason for the law is people want certainty. You want to know that if you do something or you don't do something, what the consequences are. So if you don't stop at a red light, what are the consequences? This is an industry that has been asking for the regulation. Again, what we were looking for are the least burdensome, most common sense rules. Originally under Section 333, you had to have a pilot's license, you had to have a full medical exam. It really made no sense. What you needed to go through to fly a drone was the same thing as you needed to fly a manned aircraft, and where they worried if you're in the plane alone, what happens to you? It has much more serious consequences than one would think for something that's clearly well under 55 pounds. But as was said, the FAA was tasked with safety. What happened next is that President Obama in 2015 issued an executive mandate as opposed to an executive order, and he delegated the NTIA, the National Telecommunications and Information Agency, to deal with the best practices in terms of privacy. And so there were a lot of participants, a lot of stakeholders, Amazon and Google, the News Media Coalition that NPPA is part of, and we were all at the table, and there was quite a strenuous debate about things. There were a lot of people that were really trying to create this technology-centric laws, and we really didn't want to see that happen. We felt that, as Professor West said, there were enough laws on the books, enough torts on the books that existed already that were there that would deal with the drone issue. We didn't need one specifically for technology because we were worried that they would kind of like reverse engineer it, and before you knew it, that technology specific would then kind of turn the rule on its head, and all of a sudden we'd have some privacy rights in public places where you didn't have a reasonable expectation of privacy, and that concerned us, especially with regard to the First Amendment and the ability to gather and disseminate news. So that's the mandate that came out in a memorandum. And what we ended up getting, and fortunately built some good partnerships there, is that nothing in the best practices that they put into place shall supersede the protections granted under the Constitution. And we thought that was a very important overarching principle, not just for journalism, but for everybody, because First Amendment not only protects the press, but it protects speech. And even though people think, well, it's photography, what does that have to do with speech? Photography has been deemed to be a form of expression. If you can't express yourself, you can't have speech. So that's why people photographing and recording things have that same speech protection as the people who are actually articulating words. So Again, that's some of the language that's in the best practices from NTIA. But then we have people that continue to exercise self-help. And one of the things that the FAA had done in another case to get control over everybody, not only the hobbyists, which the federal government and Congress had said, leave them alone. They've been flying since the 50s. They operate under a community set of rules, and they seem to be doing fine. The FAA went ahead anyway and classified all drones as aircraft. Whether it's a hobbyist drone, a commercial use drone, any kind of drone is still considered an aircraft. And aircraft are protected by federal law. You can't shoot in an aircraft of any kind. You can't aim lasers at the cockpits. They take that very seriously, and yet here, they wanted to get control over the drones, yet when people shoot at them, firemen aim fire hoses at them, people throw nets at them, and there are, if you look in some of the gun and ammunition books, there are all kinds of products out there that are being sold to disable, disarm, shoot down drones out of the sky. And so that's another point at which the FAA is going to have to address seriously whether or not they're going to give the same protections to drones. This, in terms of privacy, this is nothing new. Some of you heard me talk about this, but when George Eastman invented the Brownie in the 1800s, the same hue and cry went out. Privacy, the right to privacy as we know it, is over. It was the first time that somebody could take a camera in their hand, as opposed to Matthew Brady, who went around with a big covered wagon and huge equipment to cover the Civil War, or you had to sit in a studio with your neck in a brace for 5 minutes and hold still to make an exposure. Here for $1, you could buy a camera, go out in the street and take pictures. And you know, they talked about the hard camera. This is nothing new. It's literally, we now have flying cameras, but 140 years ago, they went through the same angst. And what's interesting is there's some language, and hopefully you can read it, because I don't want to read to you, but just go through this a little bit. And they talk about the right to privacy. They talk about the fact that there are these inventions coming. They basically are referring to the Brownie camera. But think about this and read it, and if you do, you could basically think that you're reading about drones today, and people complaining about the fact that, you know, Senator Feinstein, you know, claimed that she saw a drone, you know, right outside her window, which really is the nexus for her bill. So we see lots of that going on, except that it was written 140 years ago when some Harvard law students, one of whom became a very famous Supreme Court justice, Louis Brandeis, and his partner Samuel Warren wrote that. So kind of everything new, you know, everything old is new again. This is, just turn the volume down a little. So people worry about things, and there's been all this, oh my God, what's going on? So watch this video. You know, people love to take pictures out the window of things going on, and so it's playing.
But you're not in love. No.
Playing, is it moving? It should be moving. No? Did it stop? Let's see if I can. Guys, can you get it to play? Just kind of touch the screen.
It is.
Is it playing back there?
Yeah.
Okay, good. So you see what happened? Like, oh my goodness, right? Except that's all computer generated. It never really happened. Somebody decided, again, to kind of create this panic, took that video and then created what looked like a drone strike on a winglet of a Southwest plane and watched the winglet disintegrate. So that's the kind of public hysteria that's out there. There are lots of reports. For those of you who've seen drones, like a DJI Phantom is white. I've watched them. I know one is at 150 feet. It's right over my head on a clear blue sky. It's almost impossible to see. So when pilots claim that they saw a drone, and even on approach speed of about 180 knots, seeing one of these little things and claiming that it was near them is suspect, at least in my opinion. But it could happen, and unfortunately, we knew there would come a time that there would be that incident, and so the first incident just happened about a month ago, where one actually hit, and that's the rotor scrapes from a UH-60, a Black Hawk, being hit by a drone. Not much damage to the helicopter, but at least it was the first really recorded strike of a manned aircraft by a drone. So clearly, to be good stakeholders, we need to be out there. We need to be careful. Just because you pass your Part 107 and you get your little license, just the same way as you pass the written exam to drive, that doesn't mean you're a good driver. So you really do need to be very cautious and always yield the right of way to manned aircraft. The second incident, again, was just reported, this one outside of Toronto, where supposedly, or it's more confirmed, that one hit an airliner. But we're seeing all kinds of things happen. You know, I can go through some of this, but it's hard for me to see. One of the things we like to do is answer some questions, so, you know, feel free, however they're doing this. Don't everybody ask questions at once.
There's one in the front here. You can see.
Are you guys going to use mics, or do you want us to repeat the question, or how are we doing this?
We can repeat it.
What is the distinction between public events and private events as it relates to drug photography and the ability to capture?
The question is, what's the difference between a public event and a private event in terms of drone photography? I'm not quite sure I understand what you're... So the question is are there specific events that relate to drone photography? I would equate it to what's on the ground. So if you are in a public place on the ground where you have a legal right to be present, so a sidewalk or a park, a traditional public forum is the way they refer to it, you have a legal right to be present there. Whether you have a camera in your hand or not shouldn't make a difference. And it's the same thing for a drone. If you are in the proper class airspace and you're compliant with all Part 107 and somebody is outside where they have no reasonable expectation of privacy and you're complying with all the laws, then you can use your drone to capture those images.
Right, again, so the reasonable expectation of privacy. So at a public event, there would be no reasonable expectation of privacy. You're out in public, you know you can be viewed, and even a lot of private events, as Mickey was just saying, if it's happening where it can be viewed, it's a private event, but it can be viewed from the streets or from, you know, easily viewed from another vantage point, then you still wouldn't have a reasonable expectation of privacy.
And again,
well, so he asked about what it would change if you published those images. So to be liable for publicly disclosing private facts, they still have to be private. So there still has to be something private that you are revealing. And so if they are doing this in a situation that was not private, then no, you would not have liability there.
yeah, it's the same thing before there were drones. There were news helicopters. I mean, think about some of the things that we've seen with news helicopters. When we've had all kinds of aerial footage of, we've seen it at Ferguson. Well, there was a TFR, which gets into a whole other area. But I'm also thinking of like what's known as the Streisand effect. When Barbra Streisand got married, it was a big deal, and the more they tried to hide the fact that they were getting married, the more interest it developed. And they had all these big tents set up on the coast of California. And there were news helicopters up, and they photographed it. Again, it's a different set of property rights. So if I take a picture, again, we'll go back on the ground. So you're out in public. There's no reasonable expectation of privacy. We're doing a story on obesity. Can I take your picture? Sure. But think about what you see on television when they're doing that. The pictures are usually images low and shot from behind where you don't easily identify somebody's face because you don't want to hold them up to public ridicule. You don't want to hold them up to false light. There's a whole set, as we said, of property rights that belong to that person. And even though you don't have that expectation of privacy, a lot of newsrooms will err on the side of caution by shooting that generic footage and not show specifically individuals that can be easily identified. It's more of these generic shots.
And it can be a situation that seems extremely private. There's a California case where there was a car accident and they were on the side of the road and it was, very serious, very critical, and they were getting extricated from their car, clearly a very personal moment in that person's life. But we had a TV show that filmed it, and they were sued for invasion of privacy, and at least as to that part, the court said, but everybody going by on the road could see them getting extricated from the car. This was public. They didn't have an expectation of privacy in that moment because they could be seen. I mean, again, you could ask yourself whether you think it's the right thing to do, whether you think there might be a moral issue if there's something that seems, inherently to be a private moment, but legally, in that kind of situation, you don't have an expectation. And
it's a sliding scale. It's, what is the value? I mean, is it a matter of public concern that lots of people would be interested in it? The more there's value of that, the less that they would go towards the privacy.
The First Amendment still is factored in. There's right here, the glasses. See you.
That's a good question. So how high above the ground can you fly without it considering a trespass? And that's going to be a question that needs to be answered.
That's the key
because
question.
Clearly at 400 feet, you probably won't even know the drone is there, versus 10 feet and you got kids in the backyard. So I think that there's going to be a big difference. I know I get asked that question all the time, and I give the lawyerly answer of it depends. And in this case, it depends on the altitude. And I think we're going to see case law kind of break down according to that. Because right now, police helicopters fly at about 500 feet. News helicopters have another 500-foot separation. They're usually at 1,000 feet, and nobody has said, hey, at 1,000 feet, you're trespassing or invading my privacy when you're up in the air, even though the lenses on those helicopters can come much tighter in than the lenses on a drone.
Sorry.
Well, that's what we're seeing now, and I think they're trying to find the balance, as I showed you in that new pilot program. There are a number of states, Florida and Michigan in particular, who have seen that patchwork of laws from municipalities, and they basically decided to say, no, we're going to have kind of a state preemption, whereas we're going to pass a law that applies to the state, and everybody's got to fall in line. But, as you heard from Al, and you'll hear from me, and you'll hear from others, even though we think we're all sophisticated, and we know we've got all kinds of technology, this is no different than right after the Wright brothers invented the plane, in which one of them almost got killed, and died from a very serious accident. There wasn't always the FAA. They only came about in the 50s. And for a long time, there were various laws in different states, but they needed to figure out interstate commerce. They needed to figure out how were they going to fly a plane from one coast to the other without having that same patchwork of laws across the United States that would interfere, because each state decided that they were going to pass a different kind of law. And we're seeing the same thing here in municipalities, where you could be in one place and the jurisdiction says, okay, you can't fly above 350 feet, or you can't fly below 350 feet. And right next, abutting it, you got one that's picking a different altitude, and you don't even know where you are in terms of that airspace. So that's why we really need to get some common sense and least restrictive laws going, but it takes time. Some of the other challenges we're seeing, again, is we expected to see a notice of proposed rulemaking at the beginning of this year for flights over people. That didn't happen, because the Department of Homeland Security and a number of other law enforcement agencies, the FBI and so forth, were worried about the drones being armed and trying to figure out ways to identify them, trying to figure out ways to control them, and trying to figure out ways to protect public safety. So I'll go ahead a little bit. Can you play that one? So this was a kid, he's in his backyard, out in the woods. He decided, hey, let's see how this works, and he shot a video of it. He actually got prosecuted, and he was found not guilty because he basically wasn't violating any law. There was no law that said you couldn't discharge a firearm, and just because he put it on his homemade drone, again, he wasn't out in public, he was on his own property, and he did this. The next one, he decided to get a little bit more creative and figure out how to roast a turkey. And, you know, it kind of looked silly, and I thought, you know, it's a person with too much time on their hands. But then, in doing a little more research, there's this. So this is from South Korea. And what happened was there was debris that got on a high-tension line. Now, normally when that happens, they have to shut down the whole line, put a lot of people, have no power. They have to put somebody up there to get it down, endanger people. And then somebody thought, you know, these high-tension lines are built to withstand a lot of heat. Let's see what happens if we burn it off. So out of the craziness comes invention. And that's what they did there. The question was about airspace and sporting events. There have been a number of laws and regulations that have been passed in terms of where and when you can fly. And they continue to put major TFRs, temporary flight restrictions, around major sporting events, particular outdoor sporting events, such as football games, Major League Baseball. And they basically say there's no aircraft, including drones, that are able to fly. And I think they're setting like a kind of 30-mile or 3-mile, I can't remember. They keep changing, it's 3-mile. Yeah, around these events where you can't fly. And people have been flying, people have been, there was an arrest actually at a Bills game for somebody flying within that time period nearby. Again, I think we're going to start to see challenges to some of these things when there's another regulation in terms of VIPs. So when the president, the vice president, other government officials are in certain places, it basically shuts down the airspace, not just to drones, but to everybody. When I was leaving to come, I actually went to New Orleans first, but that morning I knew the vice president was coming to Buffalo for a fundraiser, and I was on a flight that was later in the morning, and the last thing I wanted to happen was to be stuck there when they shut down the airport, so I ended up changing my flight to leave early. But it's the same kind of thing that it will apply to everything, drones and regular commercial flights. I mean, it wreaks havoc with trying to have scheduling, but, you know.
I think we might have a microphone now. So
Okay,
if anybody,
great.
at least over there, if there's a question. Oh, you do.
Circle back, sorry about that. Circle back to the question about the, what I'll call image enhancing capability of today's cameras, et cetera. So the 400-foot observing marijuana in the greenhouse case was with the naked eye, and Justice Brennan made a very interesting comment about enhancing that. And then in the GPS case,
The Jones case, yeah.
Jones case, the GPS case, there's this issue of, well, we don't have to deal with the technology because this was a trespass. So they jump over to the trespass side of the right to privacy without sort of looking at it from a right to privacy. So you've got a visual observation of the naked eye at 400 feet. You've got another case, the one with the thermal imaging, where it was deemed to be tantamount to a trespass because they obtained information that they otherwise wouldn't have been able to obtain without trespassing. And there have been cases that deal with use of binoculars, high powered telephoto lenses for taking observations that said that required a search warrant. So now, put those two things together. Put a drone at 400 feet with an extremely high image capability camera, and where do you see that going? The question that really being is.
But I think, if I'm correctly understanding you, you're now talking about the government doing this.
Right.
So now we're talking about the Fourth Amendment right against unreasonable search and seizure.
Well, right, but at the same time, to a certain extent, some senses of a right to privacy still come from.
No, I disagree. If you're in a public place, there's no right to privacy. There's no reasonable expectation.
I'm not talking about that. I'm talking about being in, let's say you're in your backyard and that
Right.
drone's flying at, 400 feet,
Right.
but they're using a telephoto lens type capability on it, which do you have, when you use image enhancing things, does that change the right to privacy analysis?
And you're gonna get the same answer. It depends. It's all gonna shake out. I mean, I have no idea why are you there? I mean, it's going back to the Brownie. Everybody's like worried. Oh my God.
I'm not worried. I'm just asking
But
the
there's a
question.
drone over my house, and they're seeing God knows what. I mean, the point is that most of the time, what the drones see in their wide-angle, high-definition lens is not much of anything except a nice scenic shot.
Agreed.
At night.
There's also, there are elements that the courts will consider, as I mentioned, of offensiveness and reasonableness. So if you use that telephoto lens to peer into somebody's window when they're in their bedroom, that might be more offensive. That might seem less reasonable. But if a newscopter or a news organization uses it in a different way, that might come in at some point.
Yeah, and we're already saying there are peeping Tom laws on the books. So whether you're on the ground or climbing in somebody's tree and shooting through their window, it doesn't need to be technology specific. The example I use is, so I'm standing on a street where I have a legal right to be present, got my camera in my hand, and I'm taking a picture. I have every right to do that. You may not like it, you may ask me, I'd prefer you not take my picture, and we're seeing that a lot lately now with protests. People want to go out and they want to protest whatever they're protesting, but then they go after the photographers saying, you can't take my picture, I'm in a safe space. It's like, sorry, we get photographed dozens of times a day by surveillance cameras, by dash cams, by police body cams, because there's no reasonable expectation of privacy. So now we've got a drone hovering at the same height as my head with a camera, and it's taking a picture. Now, unless it's flying carelessly and recklessly and too close to somebody, which is an air safety, it's a reasonable governmental concern. But the point is, why should there be any difference whether the camera is in my hand or if I'm safely using it in compliance with 107 on a drone in exactly the same height? So, and I think that's where we're going to see the differentials there. It depends on the height, and it depends on what you're doing.
We got a question back here.
Would you mind talking to the educational use of these aircraft when the flight is non-recreational or non-commercial or recreational?
Well, they basically don't split it that way. It's either hobbyist or commercial use.
Right. So when does the hobbyist flight turn into a commercial flight in an educational setting?
When he or she makes some type of profit or some type of business out of doing that. When he or she earns some money, when there's some kind of transaction. I know that Matt Wade had a real problem. Matt Wade is at the University of Nebraska and started the first drone journalism lab where he thought he would teach kids about how to fly and how to use drones for news gathering. And the FAA sent him a cease and desist saying, sorry, the educational doesn't cover it because the students are paying to take the classes. Eventually, Matt ended up getting, this is still under Section 333, he ended up getting his sports pilot's license which is the cheapest way to get a license. It cost them about $10,000. Went through all the hoops, got all ready, and then the FAA said, yeah, we'll let you use it for educational use. Don't worry about it. So they're just still sorting it out as well. I think there's still a debate going on. I think it depends on how the curriculum is written for those different educational activities as to whether or not you'd need a 107. I would err on the side of that you do, because I don't see how you could claim you're doing it as a hobbyist, because you're not just flying for the pure enjoyment of it. It's got some other purpose attached to it, and there is some kind of transaction going on with a student and the school in terms of an exchange of money for credits and things like that.
This is going to be our last question.
Yes, what is the current status of the case law or precedents that's been set, say for instance the ones where individuals have shot down or impeded the flight of drones?
So far, the only case that was in Kentucky, and the court there found that the person wasn't liable for the damage to the drone. But you know, there'll be other cases, and it's a question of that was under a local law, you know, and it was a tort. You damaged my equipment. I'm suing you because, you know, it's the same thing as kind of a car accident. You did damage to my property, versus is the FAA going to come in and say you actually fired on an aircraft, which is a federal crime? And we haven't seen that happen yet,
yeah,
but I'm sure we will.
I'd be surprised if you didn't see some courts side with the drone owners, even just as a pure property, but it's still like everything.
So as you can see, it's complicated, and it depends is kind of the answer to pretty much all of the questions. So hopefully it's been somewhat helpful.
All right.
Thanks.
I'm going to hop in with one more question for each of you.
Sure.
And I'm going to do something extremely dangerous. I'm going to ask you to be brief on this one. So the question is, what can this group do when it comes to concerns about legal challenges and privacy challenges coming down the road? What should they be aware of? What's a phone call they should make, something they should pay attention to? Sonja, let's start with you on the privacy side. What's something that they should be paying attention to?
Well, I think they should be paying attention to, as we've been talking about, mostly sort of just thinking through what is this person's expectation of privacy at this moment, and I think trying to maneuver through all the patchwork and constantly change, you know, a law probably changed while we were talking here, so I mean that's really difficult. So there is a certain sense of be a good steward of the technology and think through about, you know, what could be the privacy interest here that at stake, and how can I, you know, do my work while still, you know, giving that some value.
I think the answer really is, you know, the law is in flux, so it's kind of the golden rule: do unto others. How would you? I mean, I think there should be a thought process. How would I feel if the shoe was on the other foot and I was the person that was being overflown? How would I feel? You know, should I let somebody know? It's more. It really comes down to not the legal, but the ethical part of it. And I think that's what will guide us well and keep us in good stead as stakeholders. You know, do things that make sense. You know, if there's a question in judgment, err on the side of caution. If you think you should or shouldn't fly, and it's a question, don't fly. If you see an aircraft, yield the right of way to it. I mean, again, just using common sense. There's the rules of the road. People have road rage. We see it all the time. Or you can just drive and be civil about it. So I think, you know, just doing that will be very helpful. Forget about the law and its development.
All right. Let's give a round of applause for Professor Sonja West and Mickey Osterreicher here. I think one of the big things to be taking away from this over the 2 days that you're here is that you are all stakeholders. This is your industry. This is your craft. This is something that you need to be paying attention to. And that idea of being a good steward of this in the early days of UAV flights is really important.